Thank you so much for joining in. Okay, so as I was already telling you about this course, so my name is Suvarna Dubey. I'm a learning manager at Lawctopus, and welcome to our free and open webinar on the procedure of obtaining a patent. So as you already know, intellectual property law is an area which has grown exponentially in the past few years, and IPR is, and as you already know, patent law is a really important aspect of IPR, which is often considered to be complex by lawyers. So in order to help you simplify the process of just understanding what patents are and to help you understand the procedure of obtaining a patent, today we have with us Ms. Prigya Arora. Prigya ma'am runs her own law firm called PA Legal. She has a BTech and also holds a degree in law from IIT Kharagpur. In the past, she has also worked for 3 years at Khurana & Khurana, which is a leading IPR law firm. Thank you so much, ma'am, for joining us today.
Thank you, Swarna.
Ma'am, I think we can start with the webinar. Good
Yes.
evening, everyone. Good evening, Ritvik. I can see a lot of you here, and I can also see that more of you are joining in. So we will start the webinar as and when people keep coming in. That will be great. We'll they can watch the webinar from whenever they join in. Ma'am, please go ahead.
Swarna, you'll have to give me access to share the screen.
Yes, I'll do that.
Perfect. Good evening, everyone. Pinky, Sahiba, Kushali, Yash, Roshni, Prachi, Vishnu, Priya, and everyone. So yeah, welcome to the webinar. Sorry about the initial glitch, and now it work well. My name is Prigya Arora, daughter of inspiring parent, a tech geek turned lawyer and entrepreneur, and now founder of PA Legal. And today I am here to discuss patent law with you. So are you all excited? You can write excited in the chat box, and I'll keep seeing the chat box so that I know you are with me and you're listening to me. Okay, perfect. So if you are commenting, just make sure you have change the setting to everyone and you so that your message reaches us. And with this, I'll share my screen. Perfect. So let's begin with, whenever you hear the word patent, what do you think? You can write one word that comes to your mind when you hear the word patent. What is it? Anything that comes to your mind? So Prachi says trademark, intellectual property, copyright, ideas. Perfect. What else? To own, exclusive right, innovations. Perfect. What else? Perfect. So in this webinar, what we'll do is we'll discuss what is a patent, and then we'll discuss the patentability criteria, and we'll discuss the process of obtaining a patent. So before looking into what is a patent, we have to understand what is an intellectual property. As someone mentioned in the chat box that it is a type of intellectual property. Okay. So what is intellectual property? So intellectual property is creation of mind that has some value associated with us. So whenever generally we ask this question, what is intellectual property, people generally say it is creations of mind, which is a right answer, but in a manner an incomplete answer. Why? Because if it is a creation of mind and you're not commercializing it, or it is of no value, it cannot be a property. Property has a value, property has some tangibility associated with it. Till the mind that intellectual property is in my mind and nobody knows about it, it can't be a property. To term it as a property, I have to tell about that property to Swarna, to Kushali, to Akash, to Chanchal, whoever is present here. If they do not know about my intellectual property or something which is going on in my mind, it is of no use, because then I'll be knowing it. It would be there in my mind. It would never be available for the world. So that's why we say that, you must have heard that copyright has a requirement called fixation. So that means your idea should come in some format so that people can know about it. So that is something called a creation of mind which has some value. So intellectual property can be in the form of inventions, literary artistic work, symbol, names, images used in commerce, geographical indications, trade secrets, and there are a number of other things as well. But today, the most important thing for us is a patent, and we'll understand what is a patent. Perfect. Are you all with me till now? Yes, no, maybe. And you can also keep putting your questions in the Q&A box. I think Q&A box would be active so that we'll take them at the end. Okay, perfect. So what is a patent? Patent is a set of exclusive right. First, I'll read out the definition and then I'll explain each point so that it's clear to all of us. So patent is a set of exclusive right granted by a sovereign or an intergovernmental organization to an inventor or an assignee for a limited period of time in exchange for disclosure of an invention. So let me take something to give you a better idea. So I had the nearest thing I have is this holder. So it is a holder for a tablet or a mobile phone. So let's consider this. Let us suppose that I have developed this holder and I want to patent it. What is the process? So first thing, according to definition, is it is a set of exclusive rights. That means if I have a patent on this, the rights are with me. The right to commercialize this invention is with me. And in patents, we say it is a negative right. What does the word negative right mean? Krisha says I am not visible. I think I am visible to everyone.
I think if you're using your phone to see this, then ma'am might not be visible. If it's on your laptop, then there are viewing options where you can see ma'am.
Okay, perfect. So, yeah, so it is a set of exclusive rights. Set of exclusive rights means that I'll gain some rights. In patent, it is called negative right. Why it is called negative right? It is a negative right because the right according to Act is right to exclude others from making, using, selling, offering for sale, or importing the invention. That means I have some right to stop others. In itself, from the Act, I do not have a specific right, but I have a right to stop others. That's why it's called a negative right and it is an exclusive right. Second, it is granted by a sovereign or intergovernmental organization. That means in India, patent office can give us those rights. Nobody else has the authority to give us those rights. To whom it is granted? It is granted to an inventor or an assignee of an inventor. So what does the word assignee mean? Inventor means someone who has invented an invention. Assignee means there could be a probability, like Prigya is working for Lawctopus. So if Prigya develops something for Lawctopus, Lawctopus would have the rights on it. So Lawctopus is the assignee and Prigya is the inventor. So these are two different things. Inventor will always remain the person who has invented. And assignee can change. Assignee can be a company, assignee can be a person, assignee can be an organization, assignee can be an educational institute, assignee can be anyone. But inventor, as of now till yet, can only be a person. Abhi AI ko bhi authority nahi mili inventor बनने की. So AI also not an inventor. Inventor has to be a natural person only. Okay. So next, these rights are for a limited period of time, which means that these rights are given for a limited period of time and that time cannot be extended. For example, Patent Act gives us a right to protect a patent for 20 years from the date of application. So when I have filed my application at the patent office, from that date, I'll have 20 years to exclude others from practicing my invention. And the last point is in exchange for disclosure of an invention. So as I told you, let us suppose I want a patent on this, what will I do? I'll not go to patent office and say, see, this is my product and I want a patent on this. Patent office will send me away. So what I have to do is basically draft a patent application. In that patent application, I'll mention that I want to file a patent on something which has these 3 arms, and one arm has this joint so that we can move around, so that our mobile phone or a tablet can fit in here stably. And the 2 arms on the lower portion has these grooves. The measurement of grooves is this, the measurement of arms is this, and things like that. We'll draft it in a specification. Those specification we'll give it to patent office, and the patent office will then examine the application, check the patentability criteria, and then give us the patent. So this is overall a simplified definition of what patent means. So to reiterate, it is a set of exclusive right granted by a sovereign or an intergovernmental organization to an inventor or an assignee for a limited period of time in exchange for a disclosure of an invention. Perfect. Are you all with me on this? Perfect. So you can put your questions. I see some of the questions also in the chat box. I think you can put them in Q&A box so that we can take them at the end. Or Swarna, you can make a note of these questions. Thank you. Okay, so now you all know what is a patent. Now we have to see on which things we can get a patent. So we can get a patent on a process or a method, or a machine, or a manufactured article, or a composition. So patent is related to technology. Patent is related to technology, and patent is related to technology. Don't ever make this mistake that patent is related to something else. Where there is technology, there is a patent. Where there is no technology, there are no patents. If there is a business method, there is a no patent. If there is an article, there is no patent. If there is a brand, there is no patent. If there is technology, there can be a patent, but we'll have to figure it out. So patent can only subsist in a technology, in a place where there is a technological advancement. If there is no technology, there is no patent. So don't make this mistake of saying, there can be a patent. For patent, first thing is it has to be there in a technology. And technology means there can be a process or a method, there can be a machine, there can be a manufactured article, or there can be a composition. Process or method could mean, new way of manufacturing something, new way of manufacturing this stuff what we have developed. A machine which has some rotating parts and some input and some output, that is a machine. A manufactured article could be anything: phone, mobile holder, microphone, pen, Kindle, anything available on your desk can be a product. And composition can be a composition related to pharmaceutical drugs, adhesives, paints, perfumes, and things like that. Perfect. So let us now come to the patentability criteria. So I want everybody to write in the chat box the word nuns, N-U-N-S, that you see on the screen, because I don't want you to forget this. So it's better to write it in the chat box so that I reiterate this. Okay, perfect. So why I am telling you to write this word in the chat box. So the idea of this webinar was to discuss the patentability criteria. And if you remember the word nuns, you can get a idea about what is the patentability criteria. So for patentability criteria, there has to be 4 things, 4 elements which needs to be satisfied. First is novelty, second is utility, third is non-obviousness, and fourth is subject matter eligibility. So the first letter of these words is nones. That's why I told you to write nones in the chat box. Okay. So according to Indian Act, this is the general definition. Like nones is the general criteria which is followed throughout the world. In Indian aspect, novelty is defined, like if you go through the act, novelty is determined from the word new in the definition of an invention. Utility is defined by the word industrial application in the Patents Act. Non-obviousness is defined by the word inventive step in the Patent Act. And subject matter eligibility, we have section 3 and 4, which tells us what things are not eligible to get a patent. To give you an idea, for an invention to be new, that invention should not exist anywhere in the world. For example, I have this stand which can hold a tablet or a mobile phone. So if I have developed this, then this should not exist anywhere in the world. So now you will say there can be so many, mobile holders which can exist anywhere in the world. So for novelty, we have to see exactly same product. Exactly same product should not exist anywhere in the world. So if I have this and there are many mobile holders which do not have this flexible arm, then my invention is new because I have this flexible arm which is not present anywhere in the world. Okay, so this invention as a whole, as it is, should not exist anywhere in the world. Second is utility. Utility, as you all know, should that it should be capable of being made and used in an industry. It should have some use. So if you can establish that it has some use, then it's called utility. And establishing utility is not so difficult. So we never get any objection regarding utility. The third is non-obviousness. Now here comes the difficult part while prosecuting a patent application, because in novelty, we saw that this should not exist anywhere in the world in the exactly similar manner. Now we are saying that this flexible arm is something which is novel, and because of this element, my invention is new because this flexible arm is not existing anywhere in the world. Okay, now the patent office will ask me that, is this flexible arm something obvious? Does this have an inventive step? Inventive step means technological advancement. And then I will say, because there was a long felt need, and in other inventions or other mobile phone holder, because we did not have this flexible arm, the mobile phone or the tablet used to fall down. And because of this flexible arm, I can adjust it at any height, and it can rotate in various manners according to height of my mobile phone or the tablet. My invention is not obvious to the person skilled in the art. So this kind of argument I can give, and I can say my invention is inventive. It has a technological advancement. So in non-obviousness, we have to prove what is the advancement in our product. And then comes the subject matter eligibility. Subject matter eligibility just means that Section 3 and Section 4 of our Patents Act bars some things from getting a patent. For example, things related to atomic energy are not patentable. Business methods are not patentable. And methods of doing agriculture, method of treatment of human beings are not patentable. So these are some examples which are not patentable. So to check subject subject matter eligibility, we have to go through section 3 and section 4 of the Patent Act. So if the nuns test is clear, you can again write the word nuns in the chat box. Perfect. So now let us see the registration process. So this is the overall registration process of any intellectual property. For any intellectual property, these 3 steps are absolutely mandatory. For example, the 3 steps are: the application has to be submitted at the the intellectual property office. Second step is the office checks or examines our application, and based on that check, they can either grant or reject our application. So this is a general process of any intellectual property, obtaining any intellectual property. For example, copyright, trademark, patent, and things like that. So these 3: application, examination, and then decision from the intellectual property office. So these things are absolutely mandatory. In patents, we have the specific process where the first step is application, second step is publication, third step is examination, and fourth step is called, I generally call it, the grant and the post-grant process. So let us have a look at it one by one. So the process begins with filing or the examination. Before that, even before filing or drafting the application, the first, or we call it the pre-filing work. In that pre-filing work, we analyze whether we can get a patent or not. And that analysis is done based on the nuns test. That's why patentability criteria is important. If my invention is not patentable, I'll not file a patent because the process is costly, the process is time consuming. That's why this nuns test is important, and it is done at the pre-filing stage to check whether I can get a patent on or not. Once this is clear, I will draft my application and I'll file it at the patent office. This is called the filing stage. In this stage, I have 2 options. Either I can file a provisional application or I can file a complete application. Okay, if I file a provisional application, that is a kind of interim application, not a final application. So if I file a provisional application, within 12 months, I have to file a complete application. If I do not do that, my application will get abandoned. Okay, so filing step is complete when a complete application or a complete specification is filed. If you do not file a complete specification, your application will get abandoned. Once we file a complete specification, the process will move ahead. Okay, so I'll ask one question. What is the filing date of the patent application? Just give it a try. You can write answer as complete specification or provisional specification. Write something. Provisional, okay. Provisional. Complete, provisional, provisional, complete, provisional, complete, 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 complete. Okay, perfect. So filing date of the application is always the first application. Oh, this is the different answer before 31st March. This is not the answer. This cannot be the answer. So the answer is filing date is always the date on which I have made the first application, right? So if I have filed a provisional application on 24th Feb 2022, my filing date is 24th Feb 2022. If I filed a complete application without a provisional application on 24th Feb 2022, then the filing date is 24th Feb 2022. If I have filed a provisional application today and complete application after 1 month in March, then also my filing date would be of 24th February 2022. So it is always the date of filing is always the first filing date, and it never changes. Then next step comes the date of next step is the publication. When an application is published, it is available on the IP India website, and anyone can go and see the application. And if they want to oppose our application, they can oppose our application. So that's why publication is important. Then we have examination stage. So one thing here which is important is publication can happen automatically. For example, I have filed an application. Request for publication is not important, but then we'll have to enter into a 18 months cooling down period, and after 18 months our application will get published. If we want our application to get published early, we'll have to file a request for publication. If we file a request for a publication, our application will get published within 1 month. So that is about publication. Then in examination, it is absolutely mandatory to file a request for examination. If you do not file a request for examination, your application will not get examined. So for examination, request for examination is mandatory to file. Okay. Then during examination, what can happen is the examiner can tell me, Trigya, your application needs some amendment, or we can't grant you your application, or your application is not satisfying novelty, or your application is not satisfying inventive step. Then I'll have to give them a written documents with all my arguments saying why my application is satisfying the patentability criteria and all the aspects, and why should I be granted a patent. So this is about the written documents that happen. Even after the written document, if the examiner is not satisfied, the examiner will give us a hearing. And after attending that hearing, we'll have to give them a written response of the hearing as well. So after that, they can either abandon the application, or if they are satisfied, they can grant the application. So this is the kind of overview of the patent grant process. Do you want to listen to what is the international patent grant process as well? You can write yes in the chat box if you want to. Perfect. So what we have studied up till now is the Indian patent grant process. And I know on the screen it is International Patent Grant Procedure, but International Patent Grant Procedure does not exist because we do not have anything called an international patent grant. So make sure you tell your clients that there is no international patent, because clients will come to you with a notion that, we want an international patent. They mistake themselves from the international application to be the international patent. It is just an international application. It is not an international patent. Okay. Now let us see the difference between international application and international patent. International application means I have one application which is called an international application, and it is submitted with WIPO at the International Bureau of the WIPO. So that application is called international application. Then this application, this single application can be used in multiple countries. Like when I submit an application at WIPO will give me something called as a DAS code, DAS. With that DAS code, I can go to US, I can give them that DAS code. I can go to India, I can give to Indian Patent Office that DAS code, and I can go to multiple countries, give that DAS code. And from that DAS code, the Patent Office will itself retrieve an application from WIPO, and they can process the application in their own country. So this is an international application which works in this manner, but in each individual country we need to apply. So a we need to have a process in every country, because patent rights are jurisdictional in nature. They are not global in nature, they are territorial in nature. That's why it is called international application procedure. International patent would mean that if I file one application, a global patent would be granted, which is wrong. This never happens. In each country I'll have to go through a similar process which was similar to that of India, and then I can obtain a patent in each country. To give you an idea, I'm taking this very briefly because it's not required to go into a deeper level at this stage. But to give you an idea, first an application is filed in the parent office. For example, I'll file an application in India. From that Indian application, I'll file the application in WIPO, saying my Indian application is this, and now I want to pursue an international application process. Once that is done, WIPO will issue me an ISA and an ISR, which is called International Search Report from the ISA, which is the International Search Authority. So I'll obtain an ISR and a written opinion, which is kind of an examination report which we receive from Indian Patent Office. So it is kind of similar. Then it will publish the application with the ISR and the written opinion. And then it is written that international application enters into the national phase. So then we can proceed in different countries using that DAS code and say that we have filed an application in WIPO, and you can use same application and proceed your application in other countries. So this is the overview of international patent grant process. And to give you an idea, this is how a patent application or a parts of patent application or a draft look like. So draft includes technical field. I am not going into much details of it, so I'm taking it very briefly so that you know what are the parts of the patent draft. So it includes a title, it includes a technical field, so that everybody knows that which is the technology to which our patent application relates to. Then we have the background to tell someone that to what is the problem that is existing in the art. Then we have objects of the invention, why we are making this invention. Then we have summary which is called the money paragraph, in where we briefly tell us what are the important points, and we can also include one example. Then we have brief description of drawings. This is given to indicate which drawings relate to what. For example, figure 1 is a module diagram, figure 2 is a computer diagram, figure 3 is a method diagram. So we write briefly what are the figures telling us about. Then we have detailed description where we describe the drawings in detail. Then we have advantages. What are the advantages of our invention? Then we have claims, which are the most important element of the patent draft because they give the legal eligibility to our patent application. And then we have the abstract. For example, someone is glancing through our application, reading those 150 words, the person will get aware that what is the invention about or to which technology the invention relates to. So this is about the patent application, and yeah. So this is about whatever the study part I wanted to include. And yes, I take the classes at Lawctopus Law School, and I take the live lecture once every week to get you acquainted with the Patent Act, patent process, and things like that.
You can all put your questions in the Q&A box or the chat box, whichever is more comfortable for you all. And yes, as Prigya ma'am was saying, she teaches the patent law segment of the IPR course that we have here at Lawctopus. And this webinar that you are currently seeing, this is just a small segment of what she teaches throughout the course. So this was more of a trailer of one of her classes. So yes, so I can see that there are a few questions here. Let me, ma'am, I'll put a few questions to you.
Sure.
First one is, what is the difference between a patent and a trademark?
So, see, I told you patent is related to technology, okay, and trademark is related to brand and brand name. Where there is a brand name, brand, to whichever brand you want to relate to, that is a trademark. So trademark basically relates to source of the product. जैसे ये है ना, प्रोडक्ट इस पे लिखा हुआ है ग्लिस्गा, ग्लिस्गा. So ग्लिस्गा is the trademark. That means ग्लिस्गा is the company from which this product is coming to me. But patent lies in the technology, to the functional element, what elements it has and what technology it covers. So I think that's it.
Ma'am, there's another question. Someone has asked, which website should you check for a patent, like to get a patent?
Which website? I think what they want to understand is how search is done. Like, how do we check the nuns criteria? So we have, like, if you want to do it yourself, the easiest website is patents.google.com, where they have a database of all the patents throughout the world, but you will not find Indian patents on it. Then we have IP India website, which is ipindia.nic.in, where you can go and check out the Indian patents. Then we have multiple paid databases. There is Patseer, there is Orbit, there is Derwent. There are so many of them, where we have access to those databases, and they give us combined information from all the patent offices patents. And then we can go to WIPO website, which is Patent Scope. On Patent Scope, we can search for whatever international applications are filed, and then we can also go to intellectual properties of respective countries. Main ones are USPTO and EPO. For EPO, it is espace.net. For USPTO, it is USPTO. You'll search and you'll get it.
Ma'am, are there any landmark judgments that one should read when it comes to patents?
Yeah, there are many. Like, even in India, I think Novartis case is something that everybody should read. So Novartis case is there. If anyone is interested in software, I can just say read Alice case. Alice case is not of India, it is of US, but it has the whole jurisprudence, why and what we do with softwares. So Alice case is an old case. It is of 2013 case, I think, but it is still very relevant. So I think these two are the most important ones. And then we have others as well.
Ma'am, there's another question. Can a recipe be patented?
So wherever I go, I get this question. And I think it's because, like, one of my article went viral on whether recipes can get a patent. So recipes, ideally, they should not get a patent. Even if they get a patent, I'm not saying they do not get a patent, they get a patent, but that patent is of no use. For example, see, I have a glass of water, right? Just think that I want to make something from this water. So I'll put 1 gram of sugar, 2 gram of salt, 3 gram of something else. Okay, so I'm limiting myself to 1 gram of sugar, 3 grams of salt, and whatever is the third ingredient. So I cannot change the ingredient. That becomes something very specific. So if Swarna tomorrow comes and she adds 1.1 gram of sugar here and 2.2 gram of salt, then also she is not infringing my patent, because my invention is so specific. So the whole idea behind that article, me writing that article, was there was an interesting patent on a soup recipe. Basically, it wasn't even a soup recipe. If we look at the patent, it was something like we have instant soup mix. So it was something like that. Okay, so like a person can put that soup mixture in water and a soup can be made out of it. But in that patent also it was written in similar manner that you can add like there are 2 grams of salt, 3 grams of this. So there would be no infringement in that case. Proving infringement would be so difficult, because obviously other person will say, oh, I'm not using 2 grams, I'm using 1.8 grams. What would you do? Nothing. So basically that patent was of no use. So I'm not saying you cannot get a patent, you can get a patent, but that patent is of no use. So you should tell your clients that your patent would not be of any use even if we get it.
Thank you, ma'am. I can see that a lot of you have very detailed questions about patents and just, licensing and uh, things like that. So I think it would be great if you could check out the course. I will also be telling you more about the course soon, because these are really large topics that we generally cover during the course, and we cover them over a span of 4 live sessions, 4 1.5 hour live sessions each. So I will be very soon telling you more about what the course is like, and how we do it basically, and how ma'am teaches all the sessions, and what she does during the course. So I will be coming to that more. Ma'am, there's another question. It is that if we take a patent in India, will it be valid in other countries?
So patent is a jurisdictional right, as I told you. So if it is valid in India, you can stop others from practicing the invention in India. If you want to stop people from practicing your invention in US, then you'll have to go and file in US as well. So it is a territorial right. In whichever country you file your application, in those countries only you can stop others from practicing the invention.
Ma'am, there's a question: can DNA of a person be patented?
So in section 3, we have something called living organisms, and parts of living organisms are not patentable. So I think that would fall into that category. The only exception there is of microorganisms. So I do not think DNA is a microorganism. So that's why I think it will fall into that category, and we cannot get a patent on the DNA. We can get a patent on, something like if there is an instrument, and using that instrument we are modifying the DNA, we can get a patent on that instrument, but not the DNA. So we can tweak around the application to find something which is better for us.
Ma'am, there's another question. Someone has asked, what is the difference between patent and geographical indication?
Geographical indication are, see, I'll give you example. Like this, I just told you that this is related to the brand name. For I do not have anything which I, which has a GI mark on my desk. I should keep something so that I have enough things to show to people. So yeah, for GI, what will happen is, for example, this is something which is capable of getting a GI. In GI, we'll have a similar thing यहाँ पे, which would be a GI mark. For example, you'll see Assam tea पे ऐसे हाथों वाला नमस्ते देखा होगा. So that is a GI. GI means the origin of that product is from some geographical location. For example, these things are manufactured in Rajasthan. So, and Assam tea is manufactured in Assam. So that GI tag would mean that this product originates from that specific geographical indication, location.
Thank you, ma'am. Ma'am, there's another question. What is the process of proceeding to get an international patent? How do you start that process?
As I told you, you file the application in India. Then within 12 months, you file the application in International Bureau of WIPO. And from that, the process starts. And then within 31 months from the date of priority, you can file in multiple other countries.
Ma'am, please also tell us something about a career in patent law, because that is a question that a lot of our attendees have asked today.
So see, career in patent law, I'll tell you, is very, very vast. We say that, patent is a niche field, but I do not consider patent as a niche field. So patent can have software patent as a niche, food patents as a niche, biological patents as a niche, and there are so many technology areas in themselves that can be a niche. Similarly, we have so many options. We can work in patent searching, we can work in patent drafting, we can work in patent prosecution, we can work in patent litigation, we can work in patent licensing, we can work in patent portfolio management. I think these names in themselves are sufficient to tell you what are they. For example, patent drafting means you'll draft a patent application. Searching means you'll do searches, various types of searches in the field of patents. Portfolio management means you will manage portfolios of companies who do patent work, because patents require portfolio management because they have to file in multiple countries. Then multiple patent applications have multiple deadlines and things like that. So that is another area. Then litigation is another area. Licensing, commercialization, management is another area. You have opportunities to work in law firms, then you have opportunities to work in companies, then you have opportunities to work in even educational institutes, because these educational institutes, they generally have a IP cell I'm sorry, which coordinates with law firms to file patent applications for them. So there are IP cells in, I think, most of the technology colleges. So you have opportunity to work there. So I think there are multiple opportunities in multiple areas. Just what you have to remember is there are certain areas where only technology people can work, and there are certain areas where anyone can work, and certain areas where lawyers can work. So I think most of our audience would be lawyers. So you have two options. You can work in areas where anyone can work and lawyers can work. Okay. For example, you can enter into management, licensing, litigation, portfolio management, and other aspects. What you cannot do is drafting and prosecution. That only engineers who are patent agents can do. It is a mandate by law, but there are still many opportunities like licensing, because licensing in itself is a big thing. You get to negotiate, you get to license. Then we have litigation, which is nowadays growing, and in times to come it will grow only. So for that you have to know the patent law very, very deeply. Then portfolio management, then overall management and commercialization.
Thank you so much, ma'am. Before we thank ma'am, I would just remind you that now I'll be I'll be talking more about the course that we have here at Lawctopus. Before that, I should also tell you all that ma'am has her own podcast. And ma'am, if you could just put your name or the link to it in the chat box, that would be great. She speaks to several famous people and lawyers about patent law, about IPR in general, about anything which is up and coming in that area. So
Yes.
do check out her podcast as well. And thank you so much, ma'am, for this wonderful session. It has been absolutely amazing, very insightful. Uh, just if you could just put the link or just the name of your channel or anything
So
in the
the
chat
name
box.
of my channel is Prigya, and I'm just putting the link right away. Just give me 2 minutes, and or if you search Prigya, you'll get to know about my channel as well. Sorry about that. So whenever I open my video, you'll get this sound. So let me tell you something about my podcast before I leave. So I do not only speak about intellectual property, I also speak about legal entrepreneurship and how lawyers should uh, con- how lawyers should probably live and can live and have different perspectives. For example, if you want to somewhere down the line you want to start your own law firm, your practice, so I call a number of people who answer questions related to how they started and how they built up their law firms, basically law firms or legal startups. So I talk to intellectual people related in the field of intellectual property, and many who are not related to the field of intellectual property but are still great lawyers. Like yesterday I interviewed Mitch Jackson. He is the, I think, only person in the world who is working extensively on metaverse and law, and his niche is working on web3, metaverse and law, and he calls himself as a metaverse lawyer. So that episode would be out tomorrow. Do watch that and do explore this channel and let me know your feedback. I'll be happy to take that.
Thank you so much, ma'am. Thank you so much for the wonderful session. I'll be seeing you very soon with the next patent law batch. So thank you so much, ma'am.
Thank you so much. Take care, everybody.
So before we move any further, I would love to show you a bit more about the course, because as we promised, I told you that I would be letting you know a bit more about how we do this course here. So it's taught, I mean, half of it is taught by Prigya ma'am. The patent law aspect of it is taught by her. The rest of the course is taught by Mr. H.B. Keshwa, who's also an advocate who runs his own law firm, Bhaskaran and Associates in Pune. He teaches trademark and copyright, while Prigya ma'am teaches patent law. So what we generally do is we run a 3-month long course. It's starting on 1st March. And by the way, if you have any questions regarding the course or anything, you can just put that in the chat box. I'll be happy to answer that for you. So yeah, the course starts on March 1st. It'll end on March 30th. That is if you do the entire 3-month long course. If you just wish to do the patent law course, it will start on March 1st and it'll end on March 30th. So why this course? First and foremost, it is certified by NIPO, which is the National Intellectual Property Organization. So you will have a certification from them if you decide to do this course. Also, as you already know, intellectual property is a growing area, is a viable practice, several opportunities. A number of our leading law firms today are practicing intellectual property, and a lot of them are solely practicing intellectual property. So, Sujata IP, Chadda and Chadda, Singh and Singh. There are a lot of these law firms that are solely working in this field, and so you know how massive it has become. So during this course, what we will teach you are definitely the ins and outs of intellectual property law. So we focus on both the theory as well as the practical aspects of it. So during this session, as you saw, we told you a bit about the procedure of obtaining a patent and just like the basics of it. If you decide to do the course, we go into a lot more detail regarding that. So you'll get to know a lot more about the practice and about how to do certain things. There's also in patent law, we also tell you more about patent drafting. So that becomes quite a process in itself. So this course will help you irrespective of whether you're a first year law student or you're done with your law and you're a young lawyer now. It is meant in such a way that it is supposed to build your knowledge from ground up. So you don't need to have any prior knowledge about IPR. We are here for you. We are here to help you, teach you, help you understand the whole, a lot of procedures related to IPR law. It's strong in theory, it's practical too. In otherwise, we also teach you trademark search, drafting patent specifications, registrations of patents, trademarks and copyrights, then objections, oppositions, licensing, assigning. All of those things are taught during the course. We regularly give you nudges and feedback because we have live sessions during this course. So we know that, reminders are always helpful. So we always give you reminders and feedback, anything that you require. We're all here for you. We're all here to create a very comfortable learning environment for you so that you don't feel any sort of pressure. And yes, we introduce you to the career possibilities in the field of IPR. Now, this course is completely online. It has live lectures and assignments. It consists of text-based modules, which are reading resources prepared by industry experts. The patent law resources, the patent law reading modules have been prepared by Pragya ma'am herself. Then there are recorded video lectures. We also have an online-based doubt resolution forum. So you can just put your doubts, academic doubts there, and we help you with those. We resolve those for you. And there's also, of course, you're going to have an assignment during each month. So the next month is the month of March, we'll be teaching you patents. And then after that, we'll be teaching you in the month of April, we'll be teaching you trademarks. And the month of May, we'll be teaching you copyright. So that is how this will go. If you take up only the patent law course, then your course will come to an end on 30th March itself. So just a 1 month long thing. So, but yes, we give you one assignment for each subject. So once you are done with the assignment, we give you personalized feedback. Pragya ma'am checks the assignments. She gives you her proper feedback in writing. She'll also tell you what was good in your assignment, what could be better. So we make sure that it's a very personal process so that you feel that, this is something that that your assignment was not just checked mechanically. Then this course, as I've already told you, it's completely online. We have one session a week. So that's it. Like, we just have one live session a week. We require not more than 3 hours of study in a week from you. So you don't have to, it's not going to be extremely extensive for you. You can easily do it alongside your college work or your job if you have one. It's not going to be too hectic on you. It's a 3 month long or a 1 month long course, I've told you, depending upon which course you decide to take. If you take intellectual property whole, then it's a 3 month long course because there are 3 subjects in it. If you take only patent law, then it's a 1 month long course. And of course, you get a certificate of completion at the end of the course. You may also get a merit certificate, which will be given by the founder of Lawctopus himself, if you do extremely well during the course. Also, if you do really well during the course, we help you with internship opportunities. We also help you, we give you an opportunity to publish on Lawctopus's own journal, Academic, which has an ISSN number as well. You will also get, CV advice and career counseling and things like that. So these are the courses. You can use the coupon code LLSIPLP20. I've put that in the chat box. I'll put it again. You can use this code and avail a 20% waiver, which will be, this will be available only for the next 2 days. So until February 26th. If you wish to do this course, please do use this coupon code. If you do decide to do the course, please don't pay the full amount. It makes no sense. You can get a 20% waiver at the moment. And this is only for those who came to this webinar, because we know that you're interested in IPR and this is something that, you would wish to know more about, or you would wish to gain more knowledge about. So I've put the coupon code here. I've also put the link to the course here so that you can just check the course out. Sorry, I'll just put it again. So this is the complete 3 month long course, and this is the patent law course. You can use the coupon code for either of the 2 options that you have. If you do decide to do the course, please do use the coupon code. We generally don't give 20% waiver. So this is happening only because of this webinar. So please do utilize it if you do decide to do the course. It's a really well structured course. I handle it here at Lawctopus. I've been handling this course at Lawctopus since I think since last June. So it's been quite a while now. And they gave me the course because I had done a couple of IPR internships at tier 1 law firms. So I've already interned at Singh and Singh. I've also interned at tier 2 law firms, which were working in this area, IPR, so trust legal and a few of those. So I like IPR is something that I've always enjoyed a lot, and that is the reason why they gave me this course to handle. And I can tell you for sure, Prigya ma'am is one of our finest teachers. But once you and HB Keshwa sir, who's going to be teaching trademark and copyright, he's one of the most exceptional people in this field, as well as one of the most exceptional teachers there are. If you check out our testimonials on the Lawctopus website, they're impeccable, absolutely incredible. People love these live sessions that we do. So you can check that out. You can also watch those testimonials if you wish to know more about how students have reacted to these classes. But they trust me when I'm saying this, and I'm not saying this because I'm a part of Lawctopus, but I've learned a lot during these sessions myself, because I mean, my knowledge of IPR was restricted to whatever I was taught in college. Also, if you do not wish to pay the full amount, I mean, if you do decide to do the course and you don't wish to pay the full amount in one go and you wish to pay in installments, then you can speak to Snigdha, and she can help you. If you do the 3-month long course, you can pay in 3 installments, and she will guide you through that. She'll help you through that process as well. I'll put Snigdha's number in the chat box as well, so that in case you do wish to do the 3-month long course and you don't want to pay in one go, or you're unable to pay in one go, you can speak to her and she will help you through that process. If you join the group, then I can send you her number there as well, so that it will be easier for you. Okay guys, so thank you so much for attending this webinar. We're very grateful for all of you to have been a part of this. We hope that we were able to teach you something. We hope that you enjoyed it. Please do fill the feedback form, and thank you so much. I hope that I'll see a lot of you in the course, and I hope that I'll see a lot of you in the next webinar. So bye-bye, take care, stay safe. Thank you so much guys, bye-bye.